Good afternoon, everyone. Honorable Justice Suryakant, Justice Vishwanathan, Honorable Chief Justices from various High Courts, Honorable Judges, Dr. Tulio, Sri Damu Raviji, Secretary, Ministry of External Affairs, my dear friend Gaurav Banerjee, and distinguished dignitaries. On behalf of the Government of India, I welcome the Permanent Court of Arbitration in India. And there are reasons why. We have all the reasons to welcome you with open heart. Arbitrations involving Indian parties are increasing day by day, and going by the number and value, as per the record of the Singapore International Arbitration Center, India is top foreign user since last 4 years. Notably, India has now moved up from 142nd place, which we were in 2014, and I'm giving the figures of the last 10 years. Out of 109 countries, India was 142nd in the ease of doing business as per the World Bank's ease of doing business report. Now, India has jumped in 2023 to 63rd position, and this is one of the key reasons why there is more and more foreign investment coming into India, resulting into the diversity of the litigation which can be taken care of as arbitration to be the preferred mode of arbitration, of dispute resolution. Majority of Indian arbitrations are domestic, but the institutional arbitration is also going on simultaneously and has been increasing. The faith and trust of the litigating parties in the system of institutional arbitration is increasing. Now, I'll share with you, and you must have become aware by now after all these sessions, what are the reasons why India is a preferred choice for arbitration. The first reason is a very limited scrutiny at the stage of reference to the arbitration. Apart from the arbitrations which are based upon the contract and therefore necessarily individual arbitrations, when there is an institutional arbitration or a dispute between the two parties about the appointment of an arbitrator, the matter shall necessarily go to, in case of domestic arbitration, the highest constitutional court of the state, and in case of an international arbitration, to the highest court of the country, that is Supreme Court of India, and it is decided by the Honorable Chief Justices or that designates, be it another Honorable Judge or an institution. This accelerates the appointment of arbitrator, and majority of the time which is wasted otherwise, or which used to be wasted otherwise, is taken care of. We had a confusion in the legal interpretation. What would be the parameters within which the Chief Justice or his designate would decide whether to refer a matter to arbitration or not? Whether is it permissible to go into the questions, the dispute raised between the parties, and now we have a constitutional amendment as back as in 2015, which confines the examination only on the existence of arbitration clause. Whether it is arbitrable, the dispute needs arbitration, etc., is not to be gone into. That would be gone into only when the arbitration commences. This was a major stumbling block. Major portion of delay in reference to the arbitration was attributed to this delay, which is taken care of by the amendment, and the Honorable Supreme Court has also clarified in a recent judgment of Vidya Drolia's case. Friends, the recent judgments also recognizes the incentive which a litigating party would have in the arbitration, apart from being party autonomy, one of the incentive is the speed, the expeditious nature of this particular remedy. There are several statutory provisions which are made to ensure that the arbitration is over within a time-bound period. One of the provisions is requiring an arbitration to be over within a period of 1.5 years. Those who are aware of the Indian Arbitration Act would be aware, but I'm pointing this out with a view to ensure that a word goes from India that we have a provision to ensure that the arbitral disputes are put an end to in an expeditious manner. We recently carried out an amendment in 2019, which is yet to be notified, but it permits the arbitral tribunal to be constituted by institutions. This would not only reduce the burden of the honorable courts, but would also expedite and ensure transparency and dependability if a neutral institution is appointing the arbitrator. Another reason for the success of arbitration is that in Indian court, we have recognized one new phenomena. There is a difference of treatment while enforcing an arbitral award between domestic award and the foreign award. In case when there is a international commercial arbitration and a result is award in favor of the one of the parties, then the enforcement court is not supposed to go into the question of patent illegality, because patent illegality is a phrase which is too objective and may differ from one court to another court. This is to ensure and to incentivize international commercial arbitration coming into India. India already is having flow of money, investment, infrastructure and talent. The only thing which is lacking is a reasonably speedy and dependable system of dispute resolution. Now the new amendments and the judgments, the interpretation of law given by the Supreme Court of India ensures that this takes place. Recently, there is a landmark decision in case of Avital Post Studios Limited. I believe someone must have made a mention during the previous sessions, where appellant resisted the enforcement of a foreign award which was passed in Singapore. One of the main grounds for resisting the award was that since the presiding arbitrator had failed to make a proper disclosure of material facts concerning his conflict of interest, and therefore the award was in violation of public policy, which is one of the grounds under section 48(2)(b) of the Indian Act. I'll read one paragraph from the judgment because according to me, from the perspective of Permanent Court of Arbitration, this law and this dicta of the Supreme Court would be very, very relevant. I quote, "Embracing international standards in arbitration would foster trust, certainty and effectiveness in the resolution of disputes on a global level. The above discussion would persuade us to say that in India we must adopt an internationally recognized narrow standard of public policy when dealing with aspects of bias. It is only when most basic notions of morality or justice are violated that this ground can be attracted." Then the Supreme Court refers to several other judgments delivered by it in past and says, "In view of the above discussion, there can be no difficulty in holding that the most basic notions of morality and justice under the concept of public policy would include bias. However, court must endeavor to adopt international best practices instead of domestic standards while determining bias. It is only in exceptional circumstances that enforcement should be refused on the ground of bias. Then we come to the actual conduct of arbitral proceedings, and the experience had been that there is kind of delay in disposal of the arbitral by the arbitral tribunal. What we are anticipating is good, dependable arbitrators whose arbitral awards can be trusted. Second, the arbitrator, be it a single arbitrator or a panel of arbitrator, is not burdened with so much of the arbitration work that it cannot devote sufficient time. There is a specific provision made under Section 12 of the Arbitration Act which requires a potential arbitrator to declare the way in which international community also functions. Our Indian system also functions that way so far as the statutory provision is concerned, where he has to declare whether he will be able to devote time for the purpose of effective and timely conclusion of arbitral proceedings. Our efforts are to ensure that this provision is respected and complied with in letter and spirit, so that the arbitrators who are having more work than they can handle, which results into unnecessary and avoidable delay, can be taken care of. Friends, India is the nation where the very concept of arbitration has evolved. It is only codified later, but by nature, Indians are not litigative, and they always resort to an arbitration, whether it is systematic statutory arbitration or other arbitration. I welcome the Permanent Court of Arbitration to India. They have come, though they have come late, but they have still come in time, and I hope and trust that with eminent people, eminent domain experts in the field of arbitration which are available in India, it would do a great job and the system of arbitration would succeed and progress. I'm thankful that I'm called. I'm thankful that I got an opportunity to address every one of you. I am conscious of the fact that valedictory function is the most difficult function to tolerate for the audience, and therefore I'll not take any further. Thank you so much.
Stay ahead with our cutting-edge news app. Instantly access the latest shorts in just 1 minute and breaking news in just 50 words. Download now for a smarter, faster news experience.